So this first slide is just a list of all of the topics that I hope to cover. I'm going to go through each one pretty quickly because of the time constraints, but each of these topics could be its own hour-long presentation. So just understand that I am touching the surface. And in terms of this presentation, I have some fine print on the bottom of my first intro slide that this is not considered legal advice. This is for, general informational purposes, community education for the public, and that there's no attorney-client relationship being formed by virtue of me, responding to a specific question. I just have to give that disclaimer. So consent and confidentiality. So I start here because this is really where it all begins. And for all of the parents here that have children with IEPs, you should have been, given informed consent of the evaluations and why they're being proposed and what the evaluation will look like of your child. It's important to note that consent to evaluate is not the same thing as consent to the provision of special education services. So it's really a two-part process, and you don't necessarily need to get to that second part. A lot of parents, don't really realize it, and they're like, no, I don't even want to have my child evaluated or reevaluated. But it's interesting. This is embedded in the law and the commissioner's regulations covering children with special needs, that you can consent to evaluation and not necessarily consent to the actual service. Of course, that not allowing the service to actually take place, let's say, consenting to a speech evaluation, but not allowing your child to receive the actual speech therapy, of course, down the road that can potentially pose issues if your child ends up struggling, and then now you're looking to figure out how to catch your child up. But those are definitely two different consents, and I do like to let families and individuals who work with families know that consent to one is not necessarily consent to the other. Prior written notice is very, very important. So as you all know, you sit through the IEP meeting, and you there's discussion, of course, about the different parts and what your child functioning levels are and what they need, but the prior written notice is really the DOE's kind of final notice of recommendations. It's usually accompanied by a school location letter for public school students, 5 and up, and this is really what you will receive and know, okay, this is what the DOE is intending to offer my child as an appropriate set of programming and services based on the education. And another reason why that prior written notice is important is if you end up disagreeing with this ultimate recommendation, it's really just important to know what that recommendation is, and that is what the prior written notice, or PWN, does. And then a slightly controversial point, but I am in favor of giving families information and having them come to their conclusion. Families do have the right to revoke consent altogether to special education. In my 14 years, I've only seen it happen once, where a parent wanted to sort of decertify or declassify her child from special ed services, from IEP services, altogether. And of course, it's a huge decision and something that should not be taken lightly. And there could be potentially, consequences again to taking that position. But it's important to know, even though the Department of Education wouldn't be able to force you by, let's say, an impartial hearing against you to, force the parent to continue with special education, there are potentially, child welfare consequences that the parents should be made aware of if the mandated reporter feels like the parent is sort of standing in the way of the child receiving an adequate education. And that's where education neglect referrals can happen. So language access, you have the right to meaningful participation in this CSC process, the Committee on Special Education's process of developing an IEP and finding the right school placement that can implement the IEP. So to that end, there should be translators at or an interpreter at the IEP meeting. The regulations say that districts should make every effort possible to make sure that the meetings are taking place in the parent's native language, if that would otherwise pose a barrier to the parent participating in the meeting. At an impartial hearing, which I'll go into later on, you do have the right to an interpreter at the expense of the Department of Education. And for your child, I see this with recent immigrants, there's the option of, or the option available of bilingual instruction and bilingual speech and language therapy. It's all based on your child's needs, and there are programs that do offer. I've seen, Spanish language and Mandarin, and there may be some other languages as well. So I like to think of language access not only for the parent, but also potentially for the child, him or herself. So this is a big one, the free appropriate public education. So we use this acronym. As you guys know, parents know, there are a lot of acronyms in special education, but this is the most important one, FAPE, the free appropriate public education. So we know free means that it should be at no cost to the parent. So just like you say your neighbor who has a child without a disability doesn't need to pay for her child to get a proper education, you as a special needs parent shouldn't have to pay either. So it's sort of like an equality or equitable thing with the no cost to the parent. Appropriate is where I do all of my litigation because it's so specific to the child. So there's a lot of case law, like judges' decisions that have molded what it means to be appropriate. But at its most basic level, the services have to be tailored to your child's needs. When I'm reviewing an IEP, I'm looking, if the parent is telling me, their child is a non-speaking child, then I'm looking to see if there are, strategies and goals relating to functional communication or, things like assistive technology, and we'll get into that. But it's got to be tailored to your child's needs, right? It shouldn't be sort of a template form, in terms of the IEP. We should be looking at your child's functioning levels and seeing how we can help make that child make progress or demonstrate progress over usually a calendar year. Related services are very much a part of the appropriateness of the IEP. A related service is any service that a child needs in order to access or benefit from the instruction. So I put therapies because that's, a lot of us are really familiar with OT, PT, and speech therapy. But transportation is a related service as well. So the ability of your child to get from your home to the school is a related service. And so that's why certain IEPs have different transportation accommodations and wheelchair lifts and a transportation aid. I even did a case where we had an aid that could bring the child from the door of their apartment down their walk up, because the child was in a wheelchair, and the parent and the home health aide weren't really able to do that kind of transportation. So I put that there because it's really important. Also the length of the bus ride as well. Assistive technology, it's I see it most commonly in the context of communication, but under the law it's broader than that. So I am working, for example, on a case where We're trying to look at assistive technology in assisting a child's mobility needs, and a certain chair, adaptive chair or adaptive stroller within the school environment to really enable that child to participate more fully in the instruction. And of course, nursing services, paraprofessional services, all of that has to go into the child's ability to access and learn in the classroom. And appropriate means it has to be able to produce progress and not regression. And this may sound like a really simple, a concept that shouldn't be worth saying at all, but it is, because we see IEPs where sometimes from year to year it's not changing, and yet the child is still not making progress. And so there was a relatively recent, like 5 years ago, a U.S. Supreme Court case that talked about how the district is on the hook here. You can't just kind of like copy and paste last year's IEP and keep it moving for this child who has not made progress. So something has to change, in the IEP, in this placement. And that case, it's called the Endrew case, ENDREW case. That's where the Supreme Court, U.S. Supreme Court, talked about how the goals have to be challenging and ambitious in light of the child's circumstances. So it just can't, we can't just be creating these IEPs just for the purpose of doing that without a real mission in mind, that we do want to see progress, see demonstrable academic or pre-academic progress or physical developmental progress in the child from year to year. And to that end, sometimes we do have to create goals that are going to push, not only the child, but the educators in the room to really help that child achieve what they should be achieving. Otherwise, the education will look more like, okay, this is just childcare. This is not, education if we're not pushing the child in that right direction. And public education, it means it's aligned with grade level content standards for children who are in special classes. For example, it's, the grade level content standards have to be broken down and modified to a level that the child can understand and access. And then meaningful parental participation, I bring that up again. The Department of Education, just speaking, to you parents out there, has to afford you meaningful parental participation. So you shouldn't feel like you're walking into an IEP meeting where everything has already been thought up and planned out, even before you stepped foot or offered an opinion, and that you should feel that it's a space where you can voice your opinion. And I talk more about that on the next slide. So in terms of your rights with respect to the IEP, you have the right to share reports from outside providers. So often I see parents wanting to bring their outside, if they have private insurance and their child's getting ABA, applied behavioral analysis therapy, outside of school. Sometimes they'll bring that supervisor to talk at the IEP meeting. Sometimes they'll bring a prescription from their developmental pediatrician who's recommending a certain number of therapy sessions or a certain teaching methodology. I see that with my clients on the autism spectrum. But you do have the right to do that, and I encourage families, if they do have reports or outside information to share that has bearing on the child's education, to share that in advance, with whoever the administrator is for the for that IEP meeting. You also have the right to bring a family member, an advocate, an attorney if you feel that's warranted. The law is really clear on that you can bring the support person or team that you need, as long as they have specialized knowledge about your child. and can really serve as a productive member of this committee, the Committee on Special Education. And another thing, you're allowed to give suggestions on the goals. So sometimes the annual goals are glossed over, by the parent, because it can seem like very heavy, like we're talking about like the number of times a child is going to do something within, at 80% accuracy level within 4 months. It can sound all very technical, but nothing stops a parent or their advocate from saying, you know what, I don't really get all of these different terms that you're using, but I'm concerned that my child doesn't know the alphabet, or I'm concerned that my child hasn't learned to pull down his pants at the potty, and so I want a goal about that. And that's absolutely your right to raise your real world practical concerns in your own voice. And they are supposed to address it. That's what it's comes down to in terms of meaningful participation. In various sections of the IEP, there'll be like a parental concerns section. For preschoolers, for example, it's kind of spread out between some of the different sections, the parental concerns about physical development, academic development. And when I, attend IEP meetings on behalf of clients and even for my own children, I can say, please note in the parental concern section that I have an issue with this or that I disagree with that. And they are supposed to note that. And I see that, often in IEPs that the parent disagrees or the parent feels this child needs X, Y, and Z. And so that way it's documented that you had concerns, you tried to raise them, and that can help if you end up having to take the next steps, which I will, talk about in the next couple of slides. But you don't have to agree with the special education recommendations. So if everything goes well, you won't need me necessarily, if you feel like the IEP developed is appropriate and you go and visit whatever placements are offered and it looks like it'll be a safe environment, therapeutic environment for your child, then there's really no need to necessarily disagree. You give it a shot and see how that works. And so oftentimes that can be the advice that I give families, like, it kind of looks like a solid IEP. You didn't tell me there was anything glaring when you went to visit the school, if they're still giving visits. I know certain schools have, COVID policies. But if it's the opposite, if you walk out of that, virtual IEP meeting and you're like, oh my goodness, I really felt like I wasn't heard. I really am concerned that they're not recommending this particular therapy that his doctor is recommending. You just know that you don't have to agree to the services. This plays into kind of the consent confidentiality slide, but more so this plays into kind of moving forward what rights parents have when they do disagree. So issues of least restrictive environment, this is embedded in all of the laws covering special education, from the federal down to the local regulations. Your child has the right to be educated in the least restrictive environment, in which he or she can learn. So that's really the qualifier is, a parent may want their child in a general education setting, but we have to think about what is the least restrictive in which that child can really meaningfully access the learning and education. There's a whole continuum, from general education all the way through home and hospital instruction is like the most restrictive. In between is where we have, some District 75 schools. We have, day programs that are state approved, residential programs as well. And, this is an important piece. I've been, I think as times are changing and society is looking more progressively at the issue of integrating children with disabilities with children who don't have learning differences or maybe not identified learning differences, I am seeing more often some families asking, for the child to be in some sort of inclusion setting. And I know the DOE has or is piloting certain programs with that regard. But in terms of knowing your rights, it's, least restrictive environment is a pretty important one. I think it really stems from back in the 70s when these laws came about. The special education grew out of the civil rights movement, racial segregation and integration. And then the disability rights groups started popping up and saying, well, what about us? We've been segregated as well. And, being close to home is a consideration. Interacting with typically developing children is a consideration. Proximity, the zone school, your local community school. And so you're kind of in the position as a parent of thinking, well, going along the continuum, at which point is it that my child is in the least restrictive environment? And, all of those considerations, also the size, the class ratios are embedded in this concept of making sure that the child is not unnecessarily placed in a special class with only other children with IEPs. So the independent educational evaluation, this is a big one, at least in my practice. You have the right to disagree with your child's evaluation each time an evaluation is conducted. And the evaluations are important because those are what serve the basis usually of the IEP developed. And so if your child had a bad day or a series of bad days, or you just felt like the evaluator's report doesn't quite capture your child and how you view your child and your child's needs, you have the right to disagree. And I think that this is actually a really powerful tool, advocacy tool and litigation tool in our toolbox for parents who are, looking for something different than what the district may be offering. You can think of an independent evaluation as a second opinion. Like if you went to a doctor, you got a diagnosis and you're like, well, I need a second opinion. And you can think of it in that way. And that second opinion has to be discussed and brought to the CSC, and to determine whether changes need to be made to the IEP. So independent means that it's a non-DOE employee. It'll be at, publicly funded at the DOE's expense. And if you find the right provider, that independent evaluator can actually clarify certain diagnoses. Like sometimes I have families that I think my child might be dyslexic, or I think my child has ADHD, but they just never had the means to kind of narrow down or rule out certain diagnoses. In certain cases, an independent neuropsychological evaluation can do that. And from an advocacy standpoint, I like the independent evaluations because they usually come with recommendations for strategies and teaching methodologies that would be effective for your child. So unlike sometimes the evaluations we see from school districts, where there's an analysis of the child's testing results and functioning levels, at the end, usually those evaluations say, and we defer recommendations to the CSC, to determine what IEP services may be available. With the independent evaluations, you get recommendations like your child needs ABA, or your child needs an extended year program, or your child has autism and ADHD and needs compensatory education. So it is a sometimes overlooked but very powerful tool. So I wanted to throw in here some special education rights with respect to being disciplined. And I don't know how often this is happening in the District 75 network, but to the extent a child is suspended for a period longer than 10 days or has been suspended cumulatively for a period for more than 10 school days, there should be a superintendent's suspension hearing whenever school is seeking a long-term suspension, or it's called a long-term suspension. And if your child has a disability, or being suspected of having a disability, there should be what's called an MDR. We call that here in New York City the Manifestation Determination Review, which should look like an IEP meeting where the team is looking at the alleged misconduct and in relation to your child's disability, and determining whether there's like a substantial relationship between the two, because the idea is that your child shouldn't be punished for behaviors or conduct that's pretty much out of their control. And the MDR, if it's done properly, should be an opportunity where that the committee decides to move beyond punishment, but also tweaking the IEP and considering changes to the behavior intervention plan, or for the first time conducting a functional behavior assessment. So that all of that happens if things are done the way they should be done. Your child does have the right to IEP services during long-term suspensions, and that's always something that is may not happen, I guess. It's hard to kind of recreate a special education classroom when a child is on suspension, but there is, in terms of your rights, an expedited impartial hearing process. It's a process that should, from start to finish, be completed within 30 days, where you can appeal sort of the MDR results. So if the result is that they say there's no nexus, there's no connection between your child's, having ADHD and pushing a child, near a window, then there are things that you can do to appeal. One of them is this expedited due process hearing with respect to the suspension, and also the receipt of services during the suspension. So due process. So this is like a very charged legal term, but essentially I describe it as, if your child has this legal right to an appropriate education in New York State. It's a constitutional right to be educated under the New York State Constitution. And before a government entity such as a school district, can violate your rights or impedes on this right, you have the right to challenge it. And so that's kind of what due process is all about. There are different ways in which a parent can, disagree and challenge and ask for something else. The simplest way is really the reevaluation. Some parents say, I think my child really needs a paraprofessional. This is ridiculous. I'm getting called every day to pick up the child, and yet they keep denying me the paraprofessional, and now I'm going to lose my job because I can't go to work, that whole thing. And I always say, well, try and get some letter and support from an outside provider before you ask to reopen the case. But that is, one of the like a starting point, I think, in terms of advocating for your child. There's mediation. Again, like each of these could be its own PowerPoint presentation, but that is supposed to be a non-adversarial process in which both sides get together with a neutral person, the mediator, to try and come to an agreement on what changes to be made. We usually don't see anything that involves private funding, private schools, private tuition, or tutoring, or ABA services. That cannot really be addressed in the mediation, because the individual sent to represent the DOE often doesn't have that legal authority to bind the DOE to fund things of that nature. A state complaint is good for alleged violations of patterns and practices, or just an overall violation of your child's rights beyond what, the individualized services you want your child to receive, but to just let the state know, like, well, this is what they're doing, and this is what the school district's doing, and it's a violation, and the state comes and does an investigation and interviews both sides, and then comes up with a